Hello, everyone. This is your host, Philip Reiner, and welcome to the inaugural podcast of Technology for Global Security, where I serve as the executive director. I'm a retired Pentagon civil servant, where I spent almost a decade working in the Office of the Secretary of Defense for Policy, and in my last role in federal service, I was the senior director for South Asia on President Obama's National Security Council staff. I wanted to welcome you to The Fourth Leg. This is a series of podcasts focused on one of the most complex systems in the world today, nuclear command and control, and its increasingly complicated future. Within this series, we're going to go straight to the experts across multiple sectors to talk about the modernization of nuclear command and control systems. Keep an eye on Technology for Global Security in the coming weeks and months as we begin to launch additional podcast series focused on how to fix the internet, AI and global security, and other critical technology and security related issues. For now, we have so much to talk about. Let's get started. We spoke with Air Commodore Dr. William Boothby, who was the Deputy Director of Legal Services for the UK Royal Air Force until 2011. He currently teaches at the Australian National University, at the University of Southern Denmark, and at the Geneva Center for Security Policy. So, Bill, welcome to the podcast. Thanks for joining us here today. We're really excited to speak with you on these issues. This is a complicated set of matters, even as borne out in the paper you presented. What we have been doing with all of these NC3 podcasts here on the Fourth Leg is asking folks right off the bat, particularly with kind of an eye towards listeners who may not have yet had the chance to read the paper that you provided to us back in January in the presentation you made, if you could kind of just lay down the basics of what it is that you're arguing in the piece. I think this is going to be a bit of a unique discussion as compared to some of the others we've had. So we're really looking forward to this. But what is the kind of the analysis as you lay it down in the paper, just for the listeners?
No problem. I think I start in the paper by pointing out that there are really two bodies of law with which we're dealing here. There's the body of law that talks about when it is lawful to resort to the use of force by states in particular. And then there's the other body of law that deals with the conduct of hostilities once you get involved in an armed conflict. And I think I'll start by dealing with one or two of the basic propositions on the resort to the use of force. I talk about the prohibition in the UN Charter, Article 2, the prohibition on the threat or use of force. And where a threat is concerned, I explain that for it to be a threat that would be prohibited under this provision, there has to be both the capability on the part of the threatener, as it were, to undertake the threat, and also there has to be an intent to do so. Once you've got those two things coming together, you've got what in law is called an internationally wrongful act. And that gives rise to a right on the part of the victim state not to use force, but to engage in what are called countermeasures. Otherwise, unlawful activity of a non-forceful nature that is rendered lawful, because the activity is being undertaken in response to the prior wrongful act of the state that has been issuing the threat. I distinguish a use of force that is prohibited under Article 2 of the UN Charter from an armed attack. The International Court of Justice has described armed attacks as being the most grave forms of the use of force. I know that the United States takes the view that the distinction, if you like, between armed attacks on the one hand and uses of force on the other is not much of a distinction. And in the US view, all uses of force give rise to a right to take forceful action in self-defense. That is not a widely shared interpretation. The significance of armed attacks is that they give rise, in accordance with customary law and Article 51 of the UN Charter, to the right of the victim state to take forceful action in self-defense. That happens if an armed attack occurs or if it's imminent. And the imminence issue has given rise to considerable controversy. There is a view among some commentators out there that imminence is being interpreted far too loosely, far too broadly, and that for an armed attack to be regarded as imminent, essentially the activity constituting the armed attack must almost have commenced. Certainly, if the activity has commenced, then the right to use force arises because an armed attack is occurring. The idea of imminence is best described, I think, in terms of whether this is the last feasible window of opportunity on the part of the victim state to forestall an imminent armed attack. My view is that the idea of imminence has to be construed contextually in the sense that what may be regarded as being imminent in the case of a relatively minor armed attack, grave but relatively minor, would perhaps not be interpreted in the same way if the imminent armed attack is of an extremely grave nature, such as involving the use of nuclear weapons. Legitimate self-defense presupposes compliance with two principles, necessity and proportionality. Was it necessary to use force at all? And was the force used that which was required in order to forestall the armed attack that we're talking about? The International Court of Justice has issued an opinion in the mid-1990s, an advisory opinion on the lawfulness of the threat or use of nuclear weapons. And I mentioned that in my paper. I think one can heavily summarize its conclusions, it's a lengthy opinion, that it would normally be unlawful to use nuclear weapons, but the court was unable to reach the conclusion that in extreme circumstances where the very survival of a state is in question, that use of a nuclear weapon in such circumstances would necessarily be unlawful. I think they suspected it would, but they weren't able to say that that was necessarily the case. Turning to the conduct of hostilities during an armed conflict and the law that applies in that connection, this is the other body of law that I was talking about. The principle of distinction is one of the core principles recognized by the International Court of Justice as being intransgressible. It lies at the core of the law on the conduct of hostilities. Attacks must be limited to military objectives, and there is a recognized definition, recognized by many, many, many states in the world, set forth in Article 52, Paragraph 2 of Additional Protocol 1 of 1977. The United States takes a slightly different view in relation to the definition of military objectives, in that the United States would include war-sustaining objects as well as those as set forth in the definition. Indiscriminate attacks are prohibited, and that clearly would be a rule of significant relevance in the context of some kinds of nuclear weapon. There is a targeting law rule under Article 57, Paragraph 1 of Protocol 1, which is also widely accepted as being customary in nature, and I would say would apply in the context of nuclear weapons, an obligation to take constant care to spare the civilian population and civilian objects, that is, objects and persons who are not lawful targets. There are detailed precautionary rules set forth in the law, but arguably these were rules which were introduced by Protocol 1 when that treaty was adopted in 1977. Many states, members of NATO, made statements excluding the application of the new rules in the treaty to nuclear weapons. The UK, for instance, made a nuclear statement to that effect. These detailed rules in paragraph 2 of Article 57, therefore arguably do not apply in the context of nuclear weapons as a matter of customary law, as a matter of treaty law, sorry, and therefore, by extension, it would be most unlikely that those detailed rules, would apply in the case of nuclear weapons as a matter of customary law. But I do think that the constant care obligation most certainly does apply in the context of a nuclear strike.
Bill, going back to the ICJ ruling, I think it was 1996 from memory, doesn't that ruling leave a cracked door? The door is just open to the possible legality of the use of nuclear weapons in cases of extreme threat to the state. But one question I have is, what does the state mean in this context? But if one assumes that extreme threats are at the level of existential threats or not far below existential threats, doesn't that mean that states are free to walk an entire nuclear weapon arsenal through the door and also free to make deterrent or compellant threats even to deter such existential threats? And therefore, the whole paraphernalia and metaphysics of strategic nuclear deterrence also walk through that door, until the moment that the weapons start flying, at which point law seems to just be epiphenomenal at that point, or even irrelevant.
You've wrapped up about 4 or 5 questions in one there very, very neatly.
Sorry about that.
Let me unpack a little bit and start by saying that the non-liquet part of the ICJ's judgment in 1996 was highly controversial. It was highly controversial at the time, and I think it probably remains controversial now.
Would you mind explaining that a little bit for those listeners out there who may not pick up exactly?
Well, the non-liquet is the element in the judgment that you've been referring to, i.e. the element in the judgment that said that the court could not exclude the possibility that in extreme circumstances where the very survival of the state is at issue, that the use of force might be not unlawful. That's a paraphrase of what they said, but it was in that direction. That aspect, the controversial nature of that aspect, I don't think has diminished. And certainly there was an outpouring from commentators criticizing that part of the judgment. I think, going back to what you were getting at in the latter part of your question, I would draw a distinction between deterrence on the one hand and threat on the other. For a threat to exist for the purposes of Article 2, Paragraph 4 of the UN Charter, there has to be a communication. The threat has to be communicated. And I would say it has to be communicated as a threat. Distinguish that from deterrence, where the notion of deterrence, as I've always understood it, is that actually there will be no use of nuclear weapons because we won't use them and the other side are being effectively deterred from using them. I suppose an objector to that analysis would say that implicit in the notion of deterrence is the threat that you're going to use them in certain circumstances. But that, I think, is not a threat for the purposes of Article 2, Paragraph 4. A threat under Article 2, Paragraph 4 has to take the form of a communication from one state to another and setting forth the threat to use force, often for coercive purposes. The threat is coercive in nature. If you don't do this, then we will do that. And I think therein lies the distinction.
So this distinction in deterrence that you made, I think, is extremely important, because the notion, if you go to Omaha and go to the Strategic Deterrence Symposium, which Philip went to this year, basically the slogan is that nuclear weapons avoid nuclear apocalypse, global catastrophe, millions of people being killed by nuclear weapons continuously. that we have saved ourselves over decades from nuclear war by virtue of deterrence operating in the international system. And so what's implicit in the distinction you made is that the arsenals are actually not deterring most of the time because there is no communication of threat. And of course, what lies behind communication is an intention to threaten. And in deterrence theory, if you don't have an intention, you can't deter someone by definition. So really these arsenals are, in this sense, slumbering. They're latent. They only become active threats subject to international law at the moment that another state is, as Patrick Morgan, the doyen of strategic deterrence theory in the United States in the modern era, puts it, the threats are not general but immediate. Am I understanding correctly the distinction that
I would put it the other way around, because I talked about capability plus intent. And I would think that what the possession of the nuclear weapons indicates is a capability. I think it's the fact that there is no specific intent at any particular point in time to use a nuclear weapon on a particular occasion against a particular target. That is the distinction. But I just think that the notions are different. I think that the notion of deterrence is to be distinguished from the notion of a threat for the purposes of Article 2, Paragraph 4. And I think it's important that we maintain that distinction.
Right. Of course, we don't have a lot of what you could call case law because we have Hiroshima and Nagasaki and no further uses in terms of compellence or physical use. And of course, the use in Hiroshima and Nagasaki was not deterrent. We were already at war and they didn't have nuclear weapons. So since then, what we've really had is threats, either very general and diffuse, which are, I guess, in the American sense, used to dissuade in the longer term the other party from positioning itself in a way that could ever act on its possible intention to use nuclear weapons. But we also have a series of documented public instances of the use of nuclear threat for compellence purposes in specific conflicts. Taiwan Straits crisis, the Korean War, the Soviets made threats against the Chinese. There have been a series of such instances. How do they figure into this debate? The actual political and coercive potential military use of nuclear weapons. Do they figure it all?
Maybe I can answer the question in this way. When I'm talking, or have been talking, about Article 2, Paragraph 4 and Article 51 and armed attack and right to use force in self-defense and all of that, when it comes down to a particular event, it is very often up to the victim state to determine how it will choose to characterize what has been done to it. It, for instance, may choose to say, we interpret this particular event that was done to us as being a use of force. And we therefore reserve unto ourselves the right to take countermeasures, and these, they may even say these are the actions that we plan to take, or these are the categories of action that we plan to take. There may well be all sorts of reasons that a state may have for deciding not necessarily, for instance, to characterize an event as being an armed attack, even though independent, dispassionate observers may come to the conclusion that the event was capable of being regarded as an armed attack. Therefore, when I'm teaching my students the jus ad bellum, this law on the resort to the use of force, what I try to emphasize to them is that the rules that we're talking about are rules which are aimed, or interpretations, which are aimed at delimiting whether certain kinds of event are capable of being regarded at law as being a use of force / armed attack. You've got the, if you like, the law determining whether an event is capable of being so interpreted, and then you have the essentially political decision or judgment as to whether a particular state is going to choose to interpret the event in that way. And similar events or similar looking events may be interpreted differently by different states, not necessarily because they take a different view as to the law, but because they are probably taking or interpreting their political position apropos the, as it were, aggressor state, although aggression is a very specialist concept, but you know what I mean, the aggressor state in different ways.
So this sort of brings us back to our specific topic at the workshop where you delivered your paper, the question of nuclear command and control and communications, or NC3, and commander accountability. But before we go more directly to that, I just want to ask one other question about the issue we've just discussed, which is, I think a lot of ordinary citizens around the world who aren't lawyers or politicians looked at the kind of nuclear incendiary rhetoric, annihilative rhetoric from the North Koreans over the last few years when tension was very high, and President Trump's inflammatory rhetoric, which include reference to annihilating North Korea as a country, I think was the words he used. In other words, the entire North Korean country, which had heavy denotation of the entire state and the use of nuclear force, in particular because it was combined with forced deployments that are viewed as signaling nuclear threat at the time, as being actually illegal. But it sounds from what you're saying that this is really just a political choice for the states involved, and everyone else is really just bystanders in a kind of political theater. It's not a legal issue per se, unless one side decides to take it up with the other, either militarily or presumably seeking a ruling. Who would they seek a ruling that this was illegal from? Sorry, that's my non-legal, undisciplined mind at work.
That's all right. Don't worry about it. My mind goes in the same direction on occasions. Rhetoric.
That's worrisome.
Yeah, it is. Rhetoric. My response on your rhetoric point is that states and their leaders need to be very careful. They need to be very careful because they need to bear in mind that combination, if you like, of threat and capability as being the essential ingredients to a threat in breach of Article 2, Paragraph 4. And arguably, a threat in breach of Article 2, Paragraph 4 of the UN Charter is the not quite so thick end of a particularly unpleasant wedge that would lead eventually, potentially, to a very nasty form of conflict. So I think it behoves all political leaders to take extreme care and to be very cautious over the language that they use when you're in what we used to call potentially a TTW situation, when you're in some sort of transition that could conceivably lead to an armed conflict. I think that applies all the more if you are a nuclear capable state. I get the impression that recognition may, to a certain extent, have underpinned the de-escalation of the difficult situation over Kashmir that arose earlier in the year. I think also the dangers imply the need for giving diplomacy a chance and another chance and another chance, if you see what I mean. And my understanding, or one interpretation, should I say, of the situation that arose between North Korea on the one hand and the United States on the other was that recognition was achieved in due course in the White House. And one has the suspicion that some other players, not too distant from North Korea, were perhaps instrumental in achieving an adjustment, shall we say, of some of the rhetoric that was being used. The second part of your question was who rules on legitimacy or otherwise? Who's the referee, as it were? And I would say that the International Court of Justice is certainly empowered to consider some issues of the sort that we have been talking about. But whether a case would ever go before the International Court of Justice on this sort of issue, I would rather doubt. I think where a democracy is concerned, the ultimate court is, as always, the court of public opinion. I think where international activities of this kind are concerned, there is another court, and that is the broader global court, if you like, of global opinion. And in a difficult situation, a difficult political or military, particularly a difficult military situation, no matter how big a state you are, there comes a time when you really are rather keen to make sure that you've got as many friends as possible. Certainly, I well remember 30-odd years ago, at the time of the Falkland Islands Malvinas conflict, the importance that was recognised in the UK that we should not gratuitously create non-friends, so to speak. One could put that sentiment rather more agriculturally, but I recognise the seriousness of this conversation and therefore will put it that way. I think if you're talking in terms of nuclear policy, I think those thoughts apply all the more. The final thought that you threw into your combined question was, if there were to be a nuclear exchange, are all bets off where international law is concerned? And I remember very well the view that was expressed at the meeting in Stanford earlier in the year that suggested that once the first nuke flew, forget international law. I would argue in exactly the opposite direction. I think once the first nuke flies, there will be a furious dusting off of the law books and a determination that that is the last nuke to fly. And I think ways would be found of ensuring that the law is more widely understood and complied with.
Bill, one of the I don't know enough about Kashmir, but in the North Korea-US standoff and the roller coaster ride of tension and rhetorical threat, which we have to distinguish, as purely political language. It was not part of each country's declaratory policy with respect to its nuclear weapons force, which is really what often is referred to as the twin, if you like, of the force posture in sending messages to a potential nuclear adversary. But in that cycle of political threat between Kim Jong-un and Trump, the threats that were being made were actually compellent. Neither of them were about deterring, at least in my humble opinion, about deterring actual attack at the demilitarized zone or outside of Korea between those two parties in conflict. They were each trying to force the other to change what they're already doing. In the case of North Korea, change U.S. hostile policy in many dimensions to its long-standing strategic goal. And in the U.S. case, to force the North Koreans to stop testing missiles and nuclear weapons and doing various other things that the United States doesn't like. And that's different to deterrence, which is stopping an intention from becoming an action. When you're stopping an action that's already in motion, it's a compellent threat. They're both forms of coercion, but they're very different. In such a situation where these kinds of threats are being traded, where the forces are deployed and signals are being sent, I think a lot of people in this field feel that neither party would purposefully go over the precipice ever, because they know what the stakes are. And in fact, the game is not about the actual use of force. It's about the use of the rhetoric to send a message. and try and change the mind of the adversary. It's a form of psychological warfare. But there's the risk of inadvertent war, where someone loses control, or there's an accident which could be misinterpreted in the way that your forces are operating. Where you find out that your own forces have lost control in a way that could threaten the other side. For example, you're doing an exercise of a missile using a bomber, and that missile takes off and heads for the other side's border. You don't know where it's going to land. What does international law say about your obligation to inform the potential affected party who happens to be a potential nuclear adversary? Are you obliged to warn them that this damage may be about to be inflicted upon them?
I think if you don't, and the damage is inflicted, certainly there will be one hell of a claim. It's a difficult situation that you're describing. I would agree with everything that you've said about the possibility that some of the rhetoric went beyond deterrence and was getting dangerously close to threats of the sort that we've been talking about under Article 2, Paragraph 4. I agree with that. And I think that it's therefore incumbent on those advising the senior leadership, and indeed on the senior leadership itself, to be aware of where, if you like, those boundary lines sit, and of adjusting the language that is used very, very carefully in order to ensure that the lines that we're talking about are not crossed. I well recognize that those who are given to speaking ad lib and with sometimes perhaps not as much prior reflection as one might have wished are not really going to be too receptive to that sort of message. But nevertheless, I think it's a message that needs to go out there, and it needs to be perhaps expressed by reference to the enormous responsibilities that are involved in discussion of subjects of this nature. If you send a missile, and if after you've pressed the button sending the missile, it suddenly becomes clear to you that you've made a mistake, and the person in control of the missile becomes aware of the mistake, one would have thought that these days the technology will have been built into such missiles to enable them to be disarmed in flight before arrival, as it were. Once it's arrived and detonated, self-evidently, the milk has been comprehensively spilt, and you can't undo it. But up to the point where you can undo it, if you become aware that this is all a huge mistake based, say, on a misinterpretation, based on accident, based on whatever, then there is a clear obligation that proper steps be taken to divert, disarm, etc., the missile in transit. If you're talking about a manned flight with a bomber with such a weapon on board, then the same principles apply. And clearly, you are going to be in communication with the crew, and you tell the crew to turn around and come home.
But what's the obligation under? Which legal requirement are you operating under that you have to give some warning, or are you obliged to give warning as against?
I'm not talking in terms of warning. I'm talking in terms of calling off the strike.
But if you're unable to?
Why would you be unable to?
Because there are conventional missiles that you could fire errantly that could strike your adversary, and you can't disarm them mid-flight.
Isn't it about time that we got ones where you can?
Philip, what was the example a couple of years ago?
So what Peter's alluding to is an instance in the NATO context where a Spanish F-18 errantly deployed, it sounds like it was a cruise missile that landed and set off a pretty negative reaction from the Russian Foreign Minister Lavrov and others saying, look, if this had just gone slightly differently, that could have come this way. You are all engaged in dangerous war games, and you need to back down, etc. And so it definitely pointed to a weapons capability that's out there that one could not necessarily disable once it was unleashed. And I don't remember exactly what the munition was that was accidentally launched, but it was definitely an instance where it did not get stopped on its way. And it set off a bit of an alarm bell in
And
Moscow.
it had the range to cross the border into Russia. It was in flight. And so, Bill, I asked a former Deputy Assistant Secretary of DOD. I asked an NC3 and deeply expert nuclear weapons person at RAND. I asked a person who negotiated US-Soviet strategic arms treaties. What's the legal obligation of one nuclear weapon state to another to warn the other if they're inadvertently striking the other party?
There is a general legal obligation not knowingly to use your territory, a state, not knowingly to use its territory for acts which are harmful to another state. I think when we were working on the Tallinn Manual, we took the view that that extended to your systems, certainly in the cyber context. That's my recollection. I think if you know that you have set in motion events which are, if they proceed to completion, wrongfully going to cause damage, death, and injury to an adverse party, and you do nothing in terms of warning, in terms of giving the adverse party the opportunity to do something, although what they can do remains to be seen, then I think you are going to have difficulty in resisting the allocation of blame at the political level, and you are going to have great difficulty in resisting any claims of liability at the legal level, it seems to me. And that might be one avenue, but it's inevitably, these things are very context dependent. There is online a particular piece of footage that I've seen 2 or 3 times now. It's footage which shows through the eye of a missile approaching a speck in the desert. And as the speck gets bigger and bigger, so gradually you realize that this speck is a van, a truck. And as you get nearer to the truck, the image gets sharper and bigger. Suddenly you see that the United Nations logo is on the side of the truck, and then that is the last that you see of the truck. Why? Because the missile was diverted. Now, that sort of technology is technology where you have a controller effectively either hands-on the missile or able at least to intervene. I cannot believe that it is not possible to equip the nuclear arsenal with that sort of technology.
Well, it also suggests that, you're right, these kinds of events, this kind of, I'll put it under the broad rubric of loss of control for whatever reason, and thus sending a message of inadvertent attack, which is highly ambiguous, is context dependent. If you think about satellites, satellites fall out of the sky all the time. There are the famous Soviet and Russian satellites that have fallen on various countries, as well as the international commons, as well as other countries' satellites. And some of them have done damage and required substantial cleanup costs. But there's usually a lot of advance warning. There was no sense that those events were going to lead to any of the potentially vulnerable states that received the debris raining down, including radioactive debris, lead them to attack the source country, the owner of the satellite. But where you've got very short distances and short compressed times with extreme violence potential, as in Kashmir, potentially in the Middle East, potentially in in Korea and so on. It does seem to me that, as you're saying, both the technological equipping of the forces themselves probably should be explored much more proactively and cooperatively. And also, you may need some form of nascent norm or state practice that does obligate, in such instances, some form of warning to the other party, which has implicit in it cooperation between the early warning elements of their respective NC3 systems to receive and interpret those messages with prior protocols and understandings as to what those messages mean. But at the moment, it seems to me we're so immature as an international society that we have almost none of that infrastructure in place to protect ourselves against what is almost inevitable, that kind of error.
Yeah, there's an element of the I don't know about this on my part. I have to front up on that. I do recognize that in relation to some other incidents, not necessarily, well, in fact, necessarily not nuclear in nature, that if a state felt that by fronting up and admitting that, we've lost control of this thing, that they were, if you like, acknowledging their involvement in an event where if they stayed quiet, nobody might know that it was them, that possibly was an incentive to stay quiet. But I think where you're talking about the nuclear aspect, that element of anonymity just doesn't arise. And I would therefore have thought that if there were to be an error, this would probably be a case where a state would recognize not only that there are moral imperatives to disclosing what they know as soon as they know it, but that there are also practical imperatives in the same direction of political and potentially legal nature as well. When you talked about loss of control, one thought occurred to me, of course, and that is cyber. And the recognition that loss of control may be accidental, yeah, absolutely, but equally it may be caused by cyber intrusion, cyber interference, the taking over of cyber control, if you like. And while there is no international law rule that says that a state in possession of nuclear weapons must ensure that the computer-related control systems are robust against all known and potentially some unknown interference techniques. Nevertheless, I would say that there is a practical requirement to do so, partly because if you lose control, you are no longer potentially fulfilling the military task for which you decided to fire the thing in the first place. And secondly, of course, for the obvious reason that if you lose control, it may be very difficult to attribute the cyber interference, and you as a state are simply going to be credited with having undertaken potentially a terrible attack because the person exerting control may divert the weapon to where you would least want it to go.
Phil, one of the things that the Trump administration has brought into question is the notion of one person being able to authorize a nuclear attack on another state in any circumstance. And one of the most interesting papers at the workshop where you presented was by Alex Wellerstein, who presented models, if you like, of how many people and what roles have to sign off on a nuclear attack in the different nuclear weapon states. And we discovered that there was great diversity in those systems. There was no single model. What this issue leads me to ask you is, one of the arguments is that whoever actually makes that decision and sends out an order that can then be authenticated by nuclear weaponeers who then execute the order at various levels in the command hierarchy is the question of superior orders really covering all the personnel in a nuclear weapons force. As I understand it, in the United States, the thinking is that a ruling by the Judge Advocate General at Strategic Command, and in the UK, a ruling by the Attorney General communicated to the Prime Minister, covers the entire nuclear weapons force. And this issue came up last year in the UK in the hearing on the authorization for the UK to go to war, where various former commanders of submarines suggested that a submarine commanding officer who would fire nuclear weapons does not know, but in fact has to know under international law, the target coordinates in order to make a judgment, an informed judgment as to whether they are in fact in conformity with the rules of armed conflict. Do nuclear weaponeers have a need to know all the way down to those who actually press the buttons, or are they covered by these kinds of blanket rulings in terms of how the laws that relate to targeting operate in the international system?
I think that's an incredibly difficult question to answer. It's not a sort of yes or no question. My best approach to answering it is to say, firstly, you mentioned superior orders. And one of the first things that one learns following the Nuremberg Tribunal hearings is that superior orders are no defense, that it is not a defense to an accusation of a war crime that you were acting on superior orders if the orders are manifestly unlawful. That then poses all sorts of other questions, and wherein lies the manifest illegality is clearly the core among those difficult questions. If you are a commander of a submarine, and if you know that there are lawyers who are giving advice, the Attorney General to the Prime Minister, and you know also that there is a legal hierarchy that is giving advice at the Ministry of Defence level, and so on. And if you know that your service has traditionally taken legality in these areas very seriously, and that targets for conventional attack are subjected to the most close legal, operational, intelligence, and other scrutinies, you are going to come to the conclusion that you are working within an overall organization where arrangements are in place to seek to ensure that targeting decisions are made in accordance with applicable law, and the more serious the targeting, the more closely that law is reviewed and considered. Therefore, I think, absent any indication that something is going wrong with the system, as it were, you would be within your rights in relying on that system ensuring that the orders that you received are lawful. I think anyone accusing you would have to demonstrate, if you're talking in war crime terms, would have to demonstrate that there was something about the order that was manifestly unlawful as that order appeared to you at the relevant time. And absent some basis for that, I think you are in the clear. That's probably the best I can do.
I guess, there may be, historically speaking, in the British system, I'm not sure if this is documented or not. I just don't know enough about the British case, but there may be what I'll call a clean record of consistency between the intentions of those who wield the deterrent threat, the political and military leadership, and the nature of the targets that were actually in the system militarily over the decades. In the American case, they were hugely inconsistent, and we now know this in detail up to the end of the Cold War because of the Miller study done for General Butler, which is actually spelled out in great detail in Butler's autobiography, where essentially the targeteers just took it upon themselves to go their own way, and the levels of overkill were gigantic. They were truly astounding. And in fact, Miller demonstrated, actually Butler I think it was on his first day or second day when he took command of the new strategic command that took over SAC, the Strategic Air Command, recounts where he demands a briefing on the targets. And the very first target that they review, because he insists on going through them one by one, they discover that the coordinates in the target set is wrong. And he then discovers that, in fact, the commander of the bomber force that he was now in charge of did not understand his own target set, that his own bombers were going to be bombing. And this led to, really a revolution in the way targets were selected in the American system. So if you're a weaponeer in the American system, you might be excused for thinking that there is some documentation that there could be a problem.
In which case, my response would be a bit shorter than some of my previous responses. Fix the system on the basis that it follows from what I said earlier, and this is where the answer gets a bit longer. It follows from what I said earlier that one needs a system that justifiably enables those at the sharp end pressing the fire button to know that the decision that has been made in terms of target has been the subject of the closest and most accurate scrutiny. I think that's core. And I think anything less becomes increasingly objectionable as the power yield of the weapon rises, if you like, from a mortar towards nuclear capabilities.
I know we're just about out of time, Bill, but I wanted to ask you one other question about the legal regime at a global level. As, of course, you know, a number of non-nuclear states are busy trying to get fully ratified and bring into force the Nuclear Weapons Prohibition Treaty. And this is in a context in which you have roughly 36 states that either have nuclear weapons, would deliver them, or rely upon nuclear extended deterrence. And those 36 states actually are about 56% of the world's population, and a substantial fraction of the rest of the states on the planet, roughly 100, I don't know what the exact number is now, but 190 minus 36 are either bystander states, free riders, or they're prohibitionist states who are pushing the Prohibition Treaty. How does the Nuclear Weapons Prohibition Treaty change the legal status of nuclear weapons, or does it just have no effect at all?
Well, at the moment, it has no effect at all, because there are 32 states party as of today, and the treaty itself is not in force, because there will be a set number of states that need to become party to the treaty for the treaty to enter into force, and that number has not yet been reached. I think what you have is a situation in which the states that have nuclear weapons are likely to remain outside the treaty. That is, the states that are known to have nuclear weapons. I think the states that it is suspected have nuclear weapons are also likely to stay outside the treaty, not least because staying outside the treaty increases the credibility of the belief that they have nuclear weapons, and that's the belief that they want to inculcate in others, no doubt. If the states that are specially affected remain outside the treaty, in my view, it is most unlikely that any time soon, or even in the medium term, the prohibition on nuclear weapons would become a wider recognized general rule of international law of a customary nature, thus binding on all states. I personally don't see that happening, certainly not in my lifetime, and probably not in the lifetime of the next generation below me. I'd be very surprised. What effect does it have? That was the question that you asked.
Correct.
Let me draw an analogy. And I'm going to draw the analogy and then shoot the analogy down. The analogy is the Ottawa Convention on Anti-Personnel Landmines, where there are a large number of states now that have become party to the treaty. When I last looked, those states do not include Russia, do not include China, do not include India, do not include Pakistan, do not include the United States. You get my drift. And yet, there have been significant successes as a result of the Ottawa Convention, because even states not party to the treaty, such as the United States, have adjusted their policies and behaviors to more closely align, not necessarily perfectly align, but to more closely align with the treaty. Okay? The thing that stops the Americans from participating, obviously, is South Korea, mostly. Now, that's setting up the analogy. Shooting down the analogy, I would say that nuclear weapons are fundamentally different. Fundamentally different in the sense that I see no prospect of states renouncing the possession of nuclear weapons anytime soon, states that have them. I just don't see the political will to do so. That may be my error. I'm just giving my own personal view. Indeed, in all of this, all I've been giving is my own personal views.
Well, politically speaking, it's possible that a fraction of the either nuclear infrastructure hosting countries or the allies that are dependent on extended nuclear deterrence may defect over the coming decades, in which case the sort of global balance of popular opinion and possibly states' practice in certain respects may shift. I mean, you refer there to South Korea in the context of the mines treaty. Well, of course, the South Koreans are busy trying to demine the DMZ with cooperative projects with North Korea on the ground as we speak, and fully intend to demine the entire DMZ in the future cooperatively with the North Koreans. And in fact, the former coordinator of the International Anti-Landmines Campaign is now second or third in command of the element of the Ministry of National Defense of South Korea in charge of this issue. So they have, in effect, moved their position in a way that putting increasing pressure, I think, on the United States to adjust its reliance on mines in the context of a North-South conflict. I suspect similar shifts in position may change that global balance with respect to nuclear weapons over the coming decades, but it hangs in the balance.
And that was sort of what I was getting at by drawing that sort of analogy. But on the other hand, even though I think the process you have described was very much easier, if you like, in relation to anti-personnel landmines than it would be in relation to nuclear weapons. And I think it's perhaps instructive that the area where the landmine ban became most difficult, if you like, to implement and to accept is what I'm hunting for, is in relation to territory, countries, and so on, which are able to say, we rely on these weapons to maintain the integrity of our borders. And that is the sort of reasoning that you're going to get writ large in relation to nuclear weapons. We rely on nuclear weapons to maintain our national security. And the question will be, at what point will states not only cease to be able to say that, but actually cease to believe it? Once you get to that point, and this is well outside law now, this is this is me talking about international relations. Once you get to that point, it seems to me that then all bets are off. But I personally, and this is again I keep saying it's my personal view is that it will take a number of decades at least for us to start getting in that sort of direction. I think the shaming process, if you like, that is implicit in the ICBL International Campaign for the Ban of Landmines and the Ottawa Convention and all of that is going to take much longer to gather pace in relation to nuclear weapons, unless, and this is what so often is the important point, unless something happens. And the something happening could be an event which causes the nations to come together and say, hang on a minute, we've got to do something about this.
Bill, if I could jump in here and take us back to something else that had started to come up and I wanted to seize on because it is something that I hadn't thought about when reading the paper because it really didn't get after it. But the current posture that this administration in the United States and its Department of Defense takes when it comes to multi-domain threats, if you will. So if you have something happen against critical infrastructure, that there is this now almost a doctrinal approach that nuclear response could be proportional to such an attack against the U.S. in some regard. I'm curious, as you've laid out all of the different elements of the bodies of law here when talking about distinction and eminence and the rest of it, how does that, and I'll be candid, I haven't considered the legal piece in depth as to how the U.S. could be positioned to even do such a thing or to threaten such a thing. Just curious as to how you see that in light of everything else that you've been describing here.
I think what you possibly would be best doing is not being specific. I think there are some messages best not delivered. And I think that there are occasions when, if a particular aspect of your policy ain't broke, that you quit trying to mend it. And if mere possession, coupled with very obvious efforts to update your NC3 system, very obvious occasional, when necessary, efforts to modernize the hardware, and so on and so forth, if that is sufficient to, if you like, maintain the credibility of the deterrent, I would be inclined to stick with that. I think deterrence is undoubtedly something that one needs to continually pay attention to and continually ask oneself, is this working? Not least because of the incredible costs associated with it, in many senses, not just financial. But on the other hand, I think the other contextual problem is proliferation. And the question that one has is, how do you structure your deterrent posture when you are transitioning from a bipolar situation to not just a tripolar, but a multipolar situation, where predicting the decision-making processes of some of the newer actors may well be rather difficult. But this is, we've gone way outside law now. I think that's the practical difficulty. And the beauty of the law, essentially, is that it brings us way back from those concepts and thoughts back to a straightforward approach, it seems to me, to ideas of a threat of the use of force and an armed attack and proportionate and necessary action in self-defense, and so on and so forth. I think that the other thought that I would be bound to introduce is this. In international law terms, there are differences between the United States and its allies in terms of interpretation of law. And I've published a book on this subject, as you may know, a sort of a critical assessment of the DoD Law 4 Manual. And some of those differences don't matter, but some of them do. And I well understand the hesitancies in the United States about nailing your colours to a particular legal mast and then worrying that you're going to be judged by rules which, on mature reflection, you wish you hadn't adopted, all this sort of thing. I get that. But on the other hand, I think that the strategic interest of the United States very much lies in favour of the rules-based approach. And I think the more that the United States can do going forward towards adopting the relevant rules itself, and in particular being seen to become a party to Protocol 1, if need be, subject to all of the statements that the UK made when we ratified in 98, that sort of thing, you're going to be sending quite a powerful message. I worry at the moment that the prevailing global sentiment is going far too much in the opposite direction. It's going too much in the direction of loosening the legal constraints And the classic example is the one I mentioned earlier, the idea that all uses of force give rise to the right to use force in self-defense. No, they don't. And the ICJ, the International Court of Justice, made clear its view that they don't. And I think it would be good if, for example, the US was to join what, in my judgment, is pretty much the rest of the global community in saying, okay, we accept. You see what I mean?
Yes, I do. I think
that's my reaction.
Yeah, and I think it for me at least, it's been very interesting in trying to wrap my understanding. And I was at a lunch yesterday with a relatively recently retired senior DoD official who was talking about counter value targeting during the Cold War and talking about the current state of affairs when it comes to cyber intrusions into critical infrastructure by various U.S. adversaries. And the assertion was that it's proportional, and that's just the way it is. And it's not something that I've been able to wrap my head around entirely from a legal perspective, to be quite honest, how a nuclear response to what is, in my opinion, somewhat ambiguous as to whether it falls into the category of armed attack, even when you're meddling around in a system or disabling a system, etc. This departs a little bit as well, but it isn't clear to me how those sorts of cyber activities fall out in the legal domain.
Well, I was at a meeting about 3 or 4 years ago when I remember distinctly hearing the Chinese representative arguing that, from his point of view, information and communication technologies, which is their word for cyber, or words for cyber, were regarded in the same light, I think this is the correct way of putting it, as weapons of mass destruction. And my understanding was, and I put my words fairly carefully because it was my understanding, and I may be mistaken, but my understanding was that he was drawing that parallel because of the computer controls involved in nuclear, chemical, and biological capabilities, and particularly nuclear, and the view, therefore, that cyber was capable of being used in that context. To draw a parallel between an attack on critical infrastructure and a nuclear response is, I think, very, very questionable. And it's questionable because of the twin rules of proportionality and necessity that underpin the legality of any action taken in self-defense. If you are using force following an armed attack, but your use of force goes beyond that which is necessary or proportionate, in other words, it wasn't necessary for you to use force in the first place, then you are at risk of becoming the aggressor and being regarded as becoming the aggressor. Okay? If there is a cyber attack on your critical infrastructure, I would be very surprised if a nuclear response was anything other than inappropriate on necessity grounds. It will be using unnecessary force. On proportionality grounds. It will be using a degree of force which is not appropriate to the circumstances. Okay? So that would be my response. But on the other hand, there is no doubt that cyber capabilities can be used to cause very serious consequences if certain types of critical national infrastructure are attacked, such as the electric grid in the depths of winter, for instance.
Yeah, it varies. There's quite a number of domains in which said cyber attempts could actually lead to great harm against a civilian populace. Bill, I think, as is very clear, Peter and I could continue to speak with you probably for the rest of the day. I look forward actually to continuing these conversations. I think we do have some things over the horizon in which we can do so, but I definitely wanted to say thank you so much for taking all of this time to do this podcast with us here today and for participating back in January. As always, thanks to our listeners. We'll be back next week with another episode of The Fourth Leg. Be sure to check it out. Until then, subscribe to the pod via SoundCloud, or we'll see you online via Twitter or the website. Until then, thanks to everyone for listening. We'll look forward to hearing from you.